Hello everyone, welcome to our channel. Today, we will continue our discussion concerning the kinds of obligations, classified according to plurality of object. This is actually from Article 1199 to 1206. Let's begin. Article 1199. A person alternatively bound by different prestations shall completely perform one of them. The creditor cannot be compelled to receive part of one and part of the other undertaking. Obviously, this provision talks about alternative obligations. But before we begin with Article 1199, as a background, discuss muna natin ang kinds of obligations according to object. Okay? First, simple obligation. It is one where there is only one prestation. Example, Pogi promised to repair the car of Ganda. It's as simple as that. One prestation or object of an obligation. Okay? Next, we have compound obligation. It is one where there are two or more prestations. It may be either conjunctive obligation or distributive obligation. Pag sinabi mong conjunctive obligation, ito yung maraming prestation and all of them are due. Okay? Lahat ng prestations are due. Tapos, in contrast naman kay distributive obligation, wherein although there are two or more prestations, pero isa lang ang due. Okay? It could either be alternative or facultative, which is yun yung i-discuss natin ngayon. So, now, what is alternative obligation? In essence, ang sabi ni Article 1199, alternative obligation is when several objects or prestations are due, but the payment or performance of one of them would be sufficient. Meaning, out of these two or more prestations na pwedeng ibigay, the delivery of one is sufficient to extinguish the obligation. Okay? Example, Pogi promised Ganda to deliver his car, or his ring, or his house on December 25. Dito, Pogi does not have to give all these three things enumerated. Hindi niya kailangang ibigay yung car, yung ring, tsaka yung house. Kahit isa lang sa tatlo is sufficient to satisfy the obligations. Mai-extinguish na, okay? Kasi na-comply na or na-fulfilled na. So, question. In this example, may Pogi compel Ganda to accept half of the car and half of the house? Well, the answer is actually in Article 1199 pa rin. Ganda cannot be forced to accept. Ito yung ibig sabihin ng second paragraph nga. The creditor cannot be compelled to receive part of one and part of the other undertakings. Hindi pwede yung part lang nung car, part lang nung house, di ba? Hindi pwedeng ganon, okay? It's as simple as that. Now, Article 1200. The right of choice belongs to the debtor, unless it has been expressly granted to the creditor. The debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Okay, this provision answers the question, who has the right of choice? Diba, sa alternative obligation, out of these two or more prestations, isa lang ang ibibigay and it will satisfy the obligations. Logically, the next question would really be, sino ba ang magdi-decide kung ano ang ibibigay? Right? So Article 1200 says that the right of choice belongs to the debtor. So, si debtor pala. Pero, may karugtong pa, okay? Unless it has been expressly granted to the creditor. Okay, so, general rule, si debtor ang magdi-decide. Pero, Pwede rin naman si creditor pag yun ang napag-usapan nila, na si creditor ang magdi-decide kung siya yung mamimili kung ano yung ibibigay sa kanya. Okay? So in our previous example, if sa contract ni Pogi at Ganda, wala namang nakalagay kung sino ang may right of choice. Pero si Ganda, gusto niya ang car talaga ang ibigay sa kanya. So, nagdi-demand siya ngayon na yung car ang i-deliver sa kanya. Question, is Pogi bound by the choice of Ganda? Of course, hindi. Pogi is not bound by the choice of Ganda because it is not Ganda as a creditor who is given the right of choice, absent any stipulations. Dito, sabi ko nga kanina, wala namang nakalagay kung sino ang may right of choice sa contract ni Pogi at ni Ganda. So, automatic, by the application of this law, si Pogi ang may right of choice. Okay? Second paragraph class provides that the debtor shall have no right to choose those prestations which are impossible, unlawful, or which could not have been the object of the obligation. Diba? Sabi ko nga kanina. So, meaning pala class, nagbibigay or nagbigay rin naman ng limitation ang batas as to the debtor's right of choice. Sabi, hindi rin pwede na yung piliin niya ay yung prestations na impossible, unlawful, or which could not have been the object of the obligations. To better understand ito, example, dun pa rin sa previous example natin. Si Pogi ay magbibigay kay Ganda ng house or car, or yung pangatlo, supposed lang is 1 kilo shabu. And yung pang-apat is yung stars in the sky ay ibibigay ni Pogi kay Ganda. Okay? So, meaning, pag in-apply natin tong rule na to, Pogi cannot choose the third, which is shabu, kasi ito ay unlawful. At hindi rin naman niya pwedeng piliin yung fourth, yung stars in the skies. Obviously, it is impossible. So, yung options lang talaga is either the house or the car. It's as simple as that. Now, we can move on to Article 1201. The choice shall produce no effect except from the time it has been communicated. Ayun lang. Simply said, ang choice ay walang epekto hanggat hindi pa ito na i-communicate to other party. Hanggat hindi mo pa na ipapaalam to other party, hindi ka pa nakapagbigay ng notice as to kung ano ba ang napiling prestations, alternative obligations pa siya. Okay? So, paano naman if nasabi na or nakapag-communicate ka na yung ibibigay, or in our example, nakapag-communicate na si Pogi, nakapag-notify na siya kay Ganda na ang gusto niyang ibigay ay ang car. What would then be the effect? Accordingly, the obligation then ceases to be an alternative obligation. From that time, hindi na siya magiging isang alternative obligation. Ito ay magiging simple obligation, either to do or to deliver the object or prestations na napili. Okay? In our example, it would then be a simple obligation of Pogi to deliver the car to Ganda. Ganun lang siya. Now, note class, ang batas ay hindi nangangailangan ng anumang particular na form tungkol sa pagbibigay ng notice. Meaning, pwedeng in writing, pwede rin naman verbal lang. Sabihin niya lang, tawag niya lang kay Ganda na, oh Ganda, ang ibibigay ko sa iyo ay ang itong napakaganda kong car. Ganun lang, okay? So yung choice na yon, once properly made and communicated, it is irrevocable. Pag nakapili na kung ano ang ibibigay at na-communicate na, meaning alam na ng other party, either kung si debtor ba yung may choice or si creditor man yung may choice, pag nalaman na kung si debtor at naipaalam niya na kay creditor, okay na yon. Hindi na siya alternative, siya ay magiging simple obligation. Ganun din naman, baliktad, kung si creditor naman yung may option at na i-communicate niya na kay debtor, pareho lang. It ceases to be an alternative obligation at hindi na pwedeng ma-revoke. Meaning, yun na yung ibibigay. Binding na sa inyong dalawang yun. So, sinabi na ni Pogi yung car yung ibibigay niya. Umokay na si Ganda. Okay? Tapos, hindi na pwedeng tomorrow, sasabihin na naman ni Pogi, ay ayoko nang ibigay yung car, yung house na naman. Na kay Ganda na yun kung gusto niya rin naman yung house. 'Di ba? Pero as a rule, hindi na pwedeng ma-revoke yung choice mo. Okay? So, let's proceed. Article 1202. The debtor shall lose the right of choice when among the prestations whereby he is alternatively bound, only one is practicable. Dito yung question, when does the debtor loses the right of choice? Or what is the effect when only one prestation is practicable? Okay? The answer is the obligation is converted into a simple obligation. Example, dun sa example pa rin natin, magbibigay si Pogi kay Ganda ng house or car or 1 kilo shabu or stars na nasa kalangitan. So, choices 3 and 4 is illegal and impossible. So, hindi na siya option. Now, nagkaroon ng earthquake. Gumuho ang bahay, nasira. And that's before the choice was made. Ang natitira na lang ay ang car. So, si Pogi can deliver only the car. And Article 1202 provides that, in that case, the debtor lost the right of choice. Wala na siyang choice. Ibibigay niya na lang kung ano yung practicable. So, meaning the obligation is converted into a simple obligation. It's as simple as that. Proceed tayo 1203. If through the Creditors Act, the debtor cannot make choice according to the terms of the obligation, the latter may rescind the contract with damages. Okay. Dito naman yung rule, kung hindi na makakapag-exercise si debtor ng right of choice dahil sa kagagawan ni creditor. Ang sabi, the latter, meaning si debtor, siya ay pwede niyang i-rescind ang contract with damages. Example ha, ganito class. Pogi promised to Ganda na tuturuan niya si Ganda ng obligation ng contracts in the year 2021. Or, bibilhan niya si Ganda ng sasakyan. Or, third, ibibigay niya kay Ganda yung kanyang bahay. Now, in 2021, itong si Ganda nag-abroad, pumunta sa labas ng Pilipinas at hindi na makontak ni Pogi. So, si Pogi ngayon ay nawalan ng chance to choose na yung unang option na turuan si Ganda ng obligation and contracts. So, obviously, because of the act of Ganda, kasi pumunta siya ng abroad at hindi na siya mahagilap. Okay? So, Pogi din has the right to rescind the contract plus to claim damages. But take note, class, ang sabi, may rescind, meaning it is not automatically rescinded. Meaning, the law implies that the debtor may allow it to remain enforced insofar as the possible choice or choices are involved. So, pwedeng hindi niya i-rescind. Piliin niya either gusto niya pa rin naman na nandun pa rin yung obligation niya at ang ibibigay niya ay either yung house or yung car. Ganun siya, okay? And if he chooses either the house or the car, Ganda will not be liable for damages. Okay, class? Pag yung pinili niya is to rescind the contract, yun, may damages. Pero pag yung pinili niya is yung dalawa, which is meaning gusto niya talaga is ma-enforced pa rin yung kontrata, walang right to damages or right to claim damages dun. That's it. Now, Article 1204. The creditor shall have a right to indemnity for damages when, through the fault of the debtor, all the things which are alternatively the object of the obligation have been lost, or the compliance of the obligation has become impossible. The indemnity shall be fixed taking as a basis the value of the last thing which disappeared, or that of the service which last became impossible. Damages other than the value of the last thing or service may also be awarded. This provision talks about the effect if one or more or all of the things, the prestations, or the object the debtor promised to deliver got lost. Okay? Nawala lahat ng either isa, dalawa, or lahat, di ba? So, it provides for alternative right of creditors when loss or impossibility occurs before the debtor's choice. So, class, tandaan lang natin, again, dapat para maging applicable tong provision na to, number 1, the right to choose belongs to the debtor. Okay? And second, the loss or impossibility happened before selection was made. Dapat before selection, naka-alternative obligation pa siya. Okay? So, balikan natin. Ano nga ba ang epekto if isa or dalawa or lahat? All of the things the debtor promised to deliver got lost. Okay. If some of the object was lost or become impossible through default of the debtor, okay? The debtor is not liable since he has the right of choice and the obligation can still be performed. Diba? Kasi some of the objects, hindi naman lahat. So, meaning, kahit pa fault niya, meaning, hindi pa rin siya magiging liable because nasa kanya naman yung right of choice. It is impliedly saying na yung natira, yung hindi ko sinira, yung hindi ko winala, yun yung ibibigay ko sa'yo. Kasi nasa sa kanya nga rin naman yung right of choice. Okay, class? Now, paano if lahat, all of the objects, got lost through default of the debtor? So, dito ngayon papasok si Article 1204, first paragraph, which says that the creditor shall have a right to indemnity for damages since the obligation can no longer be complied with. Okay? So, if the cost of the loss is 42's event naman, hindi naman fault ni debtor, then the general rule accordingly, di ba? Yung rule pag yung cost ng loss is 42's event, yun pa rin yung mag-a-apply, which is pag nawala, na-lost, na-damage, due to a 42's event, the obligation is extinguished. Diba? Master nyo na yan. Okay. Now, class, the phrase or the compliance of the obligation has become impossible. It refers to an obligation to do. Siyempre, hindi naman mawawala. Parang naging impossible lang. Now, second paragraph. The indemnity shall be fixed, taking as a basis the value of the last thing which disappeared. It refers to the obligation to give or that of the service which last became impossible. Okay, so dito naman, nire-refer niya yung pag-obligation to do. Okay, eto class. Pogi obliged himself to deliver to Kanda either at his option at the option of Pogi, either object 1, 2, or 3. Now, if all object were lost dahil sa kapabayaan ni Pogi, the value of the last thing that lost with damages must be given to Ganda. This is because, ganito, sabi ko nga kanina, nung nawala si object 1 and 2, suppose na ganito, yung pagkawala is in that order. Una nawala si 1, tapos si 2, tsaka yung object 3. If that's the case, nung nawala ang object 1 and 2, meaning ang obligation was converted into a simple obligation. And that is an obligation to give the object 3 to Ganda. Kaya, nung nawala pati si object number 3, yung value ni object number 3 ang magiging basis, okay? This is aside from Article 1204 saying nga na yung indemnity will be fixed taking as the basis the value of the last thing which disappeared. Yun lang yung rationale niyan. Actually, nung nawala si 1 and 2, na-converted na siya into a simple obligation. Now, suppose object 1 and 2 are lost through, ito na naman, 42th event. Tapos later, yung object 3 was destroyed by a fault of Pogi. Would Pogi be liable? Yes, nung nawala si Object 1 and 2, meaning nga, it was converted into a simple obligation. And that is an obligation to give Object 3. Now, paano if baliktad, class? Ito talaga. Baliktad. So, post, Object 1 and 2, sila yung nawala through default of Pogi. Tapos, etong si 3, siya yung nawala through a 42th event. Halimbawa, nagka-earthquake. So, nawala. Nasira din siya. And so, the question is, would Pogi be liable? Pogi had all the right in the world to destroy Object 1 and 2 since he was free not to select them. Kasi nga sabi ko, siya yung may option. Now, by destroying item 1 and 2, it only means na he is choosing item 3 para i-deliver kay Ganda. And by that, the obligation was actually converted into a simple obligation. And as a rule, if the thing was lost through a fortuitous event, the liability was extinguished. Diba? To avoid unfairness naman, dapat daw after he destroys object 1 and 2, he should have communicated to the creditor or to Ganda, in our example, at least man lang, sinabi niya kay Ganda na sinira niya si object 1 and 2 at ibibigay niya si object 3. Tapos, nung nawala dahil sa fortuitous event, the obligation is extinguished. Now, Article 1205. When the choice has been expressly given to the creditor, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Until then, the responsibility of the debtor shall be governed by the following rules. 1. If one of the things is lost through a fortuitous event, he shall perform the obligation by delivering that which the creditor should choose from among the remainder, or that which remains if only one subsists. Second, if the loss of one of the things occurs through default of the debtor, the creditor may claim any of those subsisting, or the price of that which, through default of the former, has disappeared, with a right to damages. If all the things are lost through default of the debtor, the choice by the creditor shall fall upon the price of any one of them, also with indemnity for damages. The same rules shall be applied to obligations to do or not to do in case one, some, or all of the prestations should become impossible. Eto class, where the right of choice belongs to the creditor. Makikita natin siya sa first paragraph class, di ba? For the choice to belong to the creditor, the right must expressly be given to him. And of course, same pa rin, the obligation shall cease to be alternative from the day when the selection has been communicated to the debtor. Paano? Ganun pa rin. Pwede written, pwede pa rin verbal, pwede pa rin itawag lang. Okay? Until then, bago pa ma-communicate ni creditor ang choice niya, ang responsibility daw ni debtor shall be governed by the following rules. If it is lost through a fortuitous event, si creditor daw ay maaaring pumili sa mga natitirang object or item. Now, if it is through default of the debtor, si creditor daw ay maaaring pumili sa mga natitirang object. Plus, pwede rin yung price ng item na nawala dahil sa fault ni debtor with damages. Okay. Now, pwede rin naman, paano naman pag lahat, all of the things are lost through the debtor's fault? Si creditor daw ay may right na pumili sa presyo ng anuman sa isang, kahit anong object na nandoon, also with indemnity for damages. And pag ang lahat naman ay nawala dahil sa fortuitous event, expert na expert kayo. Madali na. Article 1174 shall apply. The obligation is extinguished. So, example, class. Pogi is obliged to give Ganda either object 1, object 2, or object 3 at Ganda's option. Di ba kanina yung example natin is at Pogi's option? So, eto, dahil nga right ni creditor naman dito yung choice at Ganda's option. Before Ganda communicated his choice to Pogi, yung object number 1, sinira ni Pogi. Yung object number 2, nasira dahil nagkaroon ng earthquake. At ang natitira ay yung object number 3. Now, what are Ganda's right, if any? Ito yung sagot. Ganda can demand either. First choice niya, piliin niya yung object number 3, yung natitira pa, kasi andyan pa nga naman. And yung second option niya, piliin niya yung price or yung value ng object number 1, yung nasira dahil sa kapabayaan ni Pogi. Okay? And in either case, kahit saan dito sa dalawa, siya ay may right to claim damages. Bakit? Because Ganda has been deprived of the right to select. Diba? Tinanggalan siya ni Pogi ng option to choose either yung 1 ba or yung 3. Follow-up question. Can Ganda ask for the value of object number 2 instead? Baka suppose, mas mahal yung object number 2. Gusto niya yung object number 2 na value. Ang sagot, hindi. Why? Because it was lost through an earthquake. Hindi naman fault ni Pogi. Meaning, it was lost through a fortuitous event. Before we proceed, yung last paragraph nga pala, don't forget, same rule shall apply in an obligation to do or not to do. Okay? Itong rules na to, pareho lang, applicable din siya in case of obligation to do or not to do. Okay, tapos na tayo sa alternative obligation. Let's now compare this with facultative obligation. Article 1206. When only one prestation has been agreed upon, but the obligor may render another in substitution, the obligation is called facultative. The loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. Again, this provision defines what is facultative obligation. Ang sabi, only one prestation has been agreed upon, but the obligor may render another in substitution. Example, Pogi promised to give Ganda a car, but it was also stipulated that Pogi could give his house as a substitute. In this obligation, only the car is due, hindi kasama ang house. Kasi substitute lang naman yung house. Now, why is it important to emphasize? Ganito, dahil ang obligation naman talaga ay ang magbigay ng car. Pag ang loss ng car through Pogi's fault will make him liable. At ang sabi pa nga sa second paragraph, the loss or deterioration of the thing intended as a substitute through the negligence of the obligor does not render him liable. Meaning, ang pagkawala ng bagay na intended as a substitute, in our example, yung bahay ni Pogi, kahit pa sa kanyang kapabayaan, kaya nawala, nasira yung house, it will not make him liable kasi nga substitute lang naman yun. Okay? But class, take note of this last sentence. But once the substitution has been made, the obligor is liable for the loss of the substitute on account of his delay, negligence, or fraud. So, meaning class, from the moment or sa sandaling nagkaroon na ng substitution, na substitute na, hindi na yung car ang ibibigay, ang house na. Then, The obligor is liable for the loss of the substitute if it is lost through his negligence, delay, or fraud. Okay? Facultative obligations bear a resemblance to alternative obligations, particularly when the choice in an alternative obligation is with a debtor. But to better understand, let's distinguish this from an alternative obligation, okay? As to number of prestations, dito sa kay alternative obligation, various things are due, but the giving of one is sufficient. Pag kay facultative naman, only one is due. Yung principal lang, yun lang yung due. But the other may be given to render payment or for fulfillment of the obligation. Okay? Now, as to the right of choice, kung sa alternative, pwedeng kay debtor, pwede rin naman kay creditor pag expressly stipulated, di ba sa contract, yun yung sabi ko kanina. Dito, si debtor lang talaga ang may right of choice. Tapos, if lost through a fortuitous event, ang sabi, the loss of one or more of the alternative through a fortuitous event, dito kay alternative obligation, it does not extinguish the obligation. Pero kay facultative, the loss of the thing through a fortuitous event extinguishes the obligation. Okay? Now, in case of loss through fault of the debtor naman, sa alternative obligation, if the right of choice belongs to the debtor, the loss of one of the alternative, thus through default of the debtor, does not render him liable. Kasi nasa kanya nga yung right of choice, parang may ganung presumption. Pero sa facultative obligation, the loss of the thing due through his fault makes him liable na kaagad. Diba? And if one of the prestation is illegal, okay, the other prestation may be valid and the obligation remains. Yun pag sa alternative. Kasi baka isa lang naman yung illegal, pwede pa siyang maging valid as to the other unless siguro lahat ay illegal. Contrary naman kay facultative, kasi pag kay facultative, the nullity of the prestation agreed upon invalidates the obligation. So the debtor is not bound to choose the substitute. Paano naman if it is impossible to give? If it is impossible to give sa alternative obligation, kahit pa lahat pag may isang hindi naman imposible, the one must be given. Yung natitira, yun ang ibibigay. Pag kay facultative, pag imposibleng ibigay si principal, you do not need to give resubstitute. Okay? Kasi nga, siya naman talaga yung due na ibigay. So, that's it. Thank you for watching. Again, please like and subscribe.
Thank you for watching. If you want to see more, please like and subscribe and click that bell button para updated ka sa next video upload namin. Thanks again.